words about the topics for this week, subsequent and extensions of orders, and then a few brief words about enforcement of violations. So the OFP statute has a special provision that deals specifically with subsequent orders and extensions of orders. And the important thing to remember is that the statute has a different standard for an extension or a subsequent order than for the initial order. So to obtain an extension or a subsequent order, the petitioner would have to show that the respondent has violated a prior or existing order, that the petitioner is reasonably in fear of physical harm from the respondent has engaged in acts of stalking, or the respondent is incarcerated and about to be released, or has recently been released. So depending on what aspect of the statute the petitioner is relying on, a petitioner does not need to show physical harm nor necessarily fear for an extension or a subsequent order. And in any case, the petitioner does not need to show that physical harm is imminent. If the petitioner seeks only limited relief, such as restraining the abusing party from committing acts of abuse, excluding the party from the home they shared or her place of employment, no contact or continuing insurance, or directing the care and protection of a pet or companion animal, the statute provides that a hearing is not required unless the respondent requests a hearing. So again, you have a different standard, and in some limited circumstances a hearing may not be needed for a subsequent or an extension of an OFP. It's possible to obtain an order for protection for up to 50 years. And to do that, the court would have to find that the respondent has violated a prior or existing order for protection on 2 or more occasions, or the petitioner has had 2 or more orders against the same respondent. A 50-year order can restrain the abusing party from committing acts of domestic abuse or prohibit the abusing party from having contact with the petitioner. One thing to keep in mind is that the statute is specific in that to obtain a 50-year order, the previous orders, or the orders violated, must be orders for protection, not just any restraining order. Now I want to say just a very few words about violations. An order for protection is much more likely to be enforced if it sets out its terms in very specific language without ambiguity. So, for example, if the relief in the petition indicates that the respondent is to stay away from the petitioner, that could be open to interpretation. What does stay away mean? Rather, if the order says that the respondent must stay 200 feet away from the petitioner, that is much more specific and easier to enforce. If the order states that the respondent is not to park in front of the petitioner's house, does that mean the respondent can park 2 houses away? So you can see the potential difficulties here. So as you're working with the petitioner on the request for relief, think about how specific you can make it and how a respondent might interpret those words for his benefit to minimize their impact on him and to raise ambiguities. Once you've thought through the language from the abuser's point of view, that may help you think about how to fashion language that is concrete, specific, and much harder to manipulate. Thank you.